Well, stand up, Sharon Graham. It would appear that you have been brought up in the midst of a drug culture, which your offending is directly related to. And while in the long term, obviously, it is desirable that you be rehabilitated and rid yourself of this dreadful addiction which has burdened your life, equally obviously, crimes carried on repeatedly, one after the other, cannot possibly be overlooked.
For 27 years, George Moore has been a criminal defence solicitor. Generations of Edinburgh criminals have passed through his hands. Today, he is defending Sharon Graham. 10 years ago, her parents were regular clients. For George, the best form of defence has always been attack.
You are challenging authority, whether you like it or not. You're representing the accused who has the whole weight of the state against him. You are his only chance. There's an assumption of guilt in the whole setup. Not only do the police assume the person they arrest is guilty, and I think the court does as well. The cause of the problem is establishment-mindedness. Judges who have come from a background which doesn't give them any insight into how ordinary people live, and therefore cannot conceive the possibility of police officers lying their heads off. PF Edinburgh versus Carelia Thompson trial. Not guilty?
Guilty. Very good.
PF Haddington petition Alexander Dow Leonard Payton.
Yes.
Any questions?
No.
Well, what do you reckon about bail?
There's no chance. One's in 3 bails at the moment, and he's got a horrendous record. And the other one's got an even worse record. He's not on bail at the moment, but he's on probation.
Well, can that be checked out today?
Moore & Co. are one of the busiest criminal defence firms in Scotland, with 6 solicitors in their Edinburgh office handling up to 30 cases a day.
She was obviously in custody when this went to her house. It's for proof of income for a legal aid application. Who's dealing with that?
Well, Ewan and I are both. There's 2 cases.
Now, you had a trial in Alloa, 2 murder. Did you win it?
Well, there was 4 charges. One of assault, one of big vandalism, one urinating outside a Chinese takeaway, and another one, a breach of the peace, a 2-cop breach.
At 25 years of age, Murdo MacLeod is currently George's most experienced employee.
And it transpired that chinky bastard, it means in Chinese, wandering parentless child travelling through the countryside in the Qing dynasty.
So it wasn't
a
compliment?
It was evoked sorrow rather than being offensive.
No breach of the peace.
So no breach of the peace.
George recruits young blood. He thinks that we're more enthusiastic. It may well be that a lot of older people don't want to fight so hard. They're maybe more complacent and they want an easier lifestyle. And you certainly won't get an easy life here.
I speak to you about just check that everything's under control. Yeah, I know. Wait a minute. Hold on.
George would have difficulty getting more experienced people because they've all heard how he can be difficult to work with.
Peter Smith, Ian Brown are here. Yeah. Now what about Kenneth Davidson? They're not bringing him in.
They're not bringing him in.
So what are you going to do then?
Well, Richard's got that at the moment.
I demand a very high standard and I expect things to be done properly, and I don't like seeing shoddy work. I see my function as being a sort of ringmaster, making sure that everybody gets to the right court, that all the work's covered. Good morning. Can I just check what we've got here today? Now, am I right in thinking that Stephen Murray is an arrest coming here and not the district court?
Yes, he's coming here.
We've got James Stirling, Ian Brown and Peter Smith. Now, I would hate to be the victim of some of the crimes I defend in, and I would hate anybody close to me to be the victim. But I find very few criminal clients unpleasant people, and certainly the public's idea that criminals are men with horns and fangs and are horrible people is just a nonsense.
But Stephen Murray is here yet. Stephen Murray is not here yet.
Every morning throughout the court building, George's team are locating clients, listening to their stories and defending them in court.
Lord, my name is Harrower. I appear on behalf of Mr. Boyle. Lord, I would make a motion for Mr Boyle's liberation pending trial.
If you do get the 12:30 train and there's delays, you're running in at 1:45, 1:45, and it's too late then to get yourself booked in and through the court, because you've got to straight away ask.
The breach of community service has to go back before Sheriff McNeil properly. If it goes back before Sheriff McNeil, all right, at least it gets you off the street, and that's the main thing, because you've been now fixed about.
There's a nice beer belly for you. Yeah? That's cost him a fortune.
When's your girlfriend's baby due? February. Do you live with her? No.
Ewan, check when you're down there if there's any custodies, because I don't...
Yeah, no, Richard's been down
Richard's
already.
been down, okay. Oh, God. Tired before I start.
With regard to the new complaint, my lord, he tenders a plea of not guilty in respect of that complaint also. My lord, I would intimate that I'm not in a position to move for bail today.
The vast majority of people who come into these courts are there because they're poor. The underclass that we talk about, people who are not educated and people who really don't have any real stake in society.
Today, George is again defending Sharon Graham. This time she is charged with shoplifting and assault. George can't dispute that she had stolen clothes in her possession, but will fight the case on a legal technicality.
You shouldn't give evidence, Sharon, because if we lose the legal argument, then you would have to admit that these items were stolen. Do you follow me? The other items, and that would be the end of the case. Now, I'm going to argue that what has happened is a citizen's arrest which is not warranted. In other words, it's not a legal citizen's arrest. And I've got a lot of authority here for it. Now, the point about doing that is if that's successful, if it's successful, then you're entitled to use force to resist an illegal arrest by a citizen. Well, our background is that both mother and father have been drug addicts, and both are affected by HIV. Her mother's got AIDS. She herself is a drug addict. She has 2 young children to look after and tries her best to look after these children. It's a very bleak situation. She really doesn't have much of a chance now, really.
The female that you saw, do you see her in court here today?
Yeah.
Just point to, let me see her, please. Just point to the lady sitting here at the front of the court in the pink jacket. What was she doing when you first saw her?
She was acting rather suspiciously at a bay to the rear of the ground floor.
Where did you say?
Just to the rear of the ground floor. She was rolling up one of my garments, ready to deposit into a poly bag.
And what happened then?
She actually caught sight of me watching her, so she discarded the garment on the top of the fixture. I had then looked over to my security guard to actually meet her going towards the door. She went, "Look, I've not got your stuff." And I said, "Well, if you'd just like to come to the office and we can clear this up."
Right, so what happened then?
We got into the back stairwell and we went up the first flight of stairs and we started going up the second flight of stairs. The security guard was to sort of like the left of her and I was just behind her, but two steps down from her at her back, and she turned round and kicked me straight on in the face, and I fell backwards down the stairs. But she'd shouted at the time, "You fucking cow."
Then you say Stephen Campbell comes out with a knife.
Certainly did.
A black-handled knife, some 8 inches long.
That's quite correct.
In court number 4, George's newest recruit, Jim Stevenson, is defending 19-year-old Stephen Campbell on charges of breach of the peace and possessing an offensive weapon.
You are saying that Mr. Campbell's in brandishing the knife.
Furiously waving the knife towards his face.
Towards his face? Furiously waving the knife towards his face? Full outstretched arm?
I would say that's quite correct, yeah.
See, I've got to suggest that that's not what happened at all. I've got to suggest that anything Mr. Campbell did was purely to ward off Mr. Bernard McLeish and Stephen McLeish, who were coming towards him.
I'd say that was untrue.
I've got to suggest that Mr. McLeish actually punched Mr. Campbell when they approached him after a short argument. What do you say to that?
Whilst I'm under oath, and it's for me to tell the truth. I would say that that was incorrect.
Do you know the colour of the cardigan?
Blue.
So that's right, is it? Blue?
It was blue. Blue woolen waistcoat, £12.99.
Right. Did you recover that item of clothing?
It was thrown on top of the
Did you recover it?
It was thrown on top of
Did
the
you recover it?
Just a minute, Mr. You're being asked, did you recover this item?
There's a fond belief that witnesses all go into court to tell the truth. I don't believe that. I believe that witnesses take a stance very often and decide that they're going to give a particular type of evidence. It's amazing how often you can actually change a witness's evidence by cross-examination.
You mean get back into the store yet?
You did?
Well, what do you mean? I'm not sure what everybody's saying here.
You can't remember
No,
something. Just say you can't remember.
No.
Some people think I'm a bit rude and aggressive. And if it upsets them, I'm afraid that's just too bad. You see, I have to put it to you that you're not telling us the truth about this. That all that my client did was take off from a hanger a blue cardigan and put it back.
Well, it is my word against her word. I appreciate that.
Can you just answer that question, please?
Well, she took it off the hanger and rolled it in a ball towards putting it in the bag.
Oh, yes.
But obviously, then looking around to see if anybody was watching, noticed that I was watching, so then threw the garment back over on top of the bay.
You've said that.
Yeah, I just want to make myself clear.
So I'm putting it to you that did not happen. And that's something you've made up to give you a reason to approach this girl.
It's not true.
And what happened was that you simply went up to the accused and took hold of her bag. You asked her if there was anything stolen from your store in it, and she said no. But you insisted, nevertheless, in looking through it.
No, I didn't go through the bag.
Yeah?
No.
On the other side of Edinburgh, a man has been stabbed to death. A police forensic team examined the scene, but already a Moore & Co. client is being held on a murder charge in St Leonard's police station. Murder MacLeod has been sent to see him.
So, you were about 10 feet away and your pal, you say, stabbed the Arabian once, maybe twice. Was that to the front of him or?
Side, I think.
The client insists that he is innocent, but admits to being in the room when the stabbing took place.
So the Arabian chap was moaning quite a lot?
Aye.
When you say moaning, do you mean he sounded as if he was in pain?
Pain, aye.
What sort of knife was it?
Oh, it's a big one. A big kitchen knife.
Now, am I not right in saying that Mr. Chalmers had a hold of my client's arm, and that what actually happened was, having freed her arm from the security guard, she fell backwards onto you?
With her foot going back the way.
Well, I'm suggesting that she fell backwards onto you and that you then fell down.
No.
And if you injured yourself at that point, if you did, it was a result of that accident.
No.
Right, thank you.
Just step forward.
The next witness is the store detective who arrested Sharon, and it's the events surrounding the arrest that interest George.
Did you not take her by her left arm? Did you take her, put your hand on her left arm and lead her to the stairway?
I put my hand out, but didn't actually touch.
Pardon?
I just put my arm out just to signal where to go.
Is that right? See, that's just not true. You took hold of Sharon Graham's left arm and led her to the stairway.
No, I put my arm out like that, guided her to the staircase.
Well, how did you manage to guide her if she was protesting and not wanting to go?
She did go herself, a walk.
Well, that's not true, is it? And all of this time she was protesting and not wanting to go, and that she tried to struggle to get her arm free from you because you were hurting her.
No, that's not true.
That you were holding on to her and she kept pulling her arm away from you and eventually freed it and fell over backwards.
That's not true.
And when she fell over backwards, she fell onto Miss Dixon, who also fell over backwards.
That's not true.
The purpose of George's cross-examination is to set up the legal argument that he hopes will get Sharon off the hook.
The legal argument is that the people in the store where she was apprehended made a citizen's arrest, and if the citizen's arrest is illegal, then that allows her to use force to resist that arrest, and it also might mean that the finding of stolen property in her possession is inadmissible, and if that evidence is inadmissible, then she's entitled to be acquitted on the theft charges. So this was somebody assaulting Miss Dixon who had, according to you, decided to go with you?
Yes.
But who nevertheless was not free to leave?
No, because we went for the police to arrive to further
So
inquiries.
was not free to leave. Is that right?
She could physically run away, yes.
But you would have stopped her if she tried to do that?
Yes.
Right.
Several more witnesses give evidence that the clothes found in Sharon's bag were stolen. George doesn't dispute this, but it will all be irrelevant if the sheriff accepts his legal argument.
What has happened here is a citizen's arrest. And in my submission, the evidence does not warrant the citizen, namely the witness in this case, to effect an arrest. Now, my Lord, there are two recent cases on citizen's arrest, and these are Cadona versus Cardle and Bryans versus Guild, and I think it's fairly clear that a citizen cannot detain because the citizen is suspicious that something's happened. As a lawyer, I look at a case principally to see whether the Crown can prove the case by proper legal methods, and if there's an escape route for an accused person, that accused person's entitled to take that escape route.
Sheriff Breslin, however, is not convinced.
There is no reasonable doubt raised in my mind, despite the submissions of Mr. Moore, and I find charge 1, the accused is guilty, and similarly on charge 2. I'm going to defer sentence for 3 weeks for a social inquiry report and a community service assessment. Looking at the number and nature of the charges here and the numerous previous convictions, in my opinion, the accused has been pursuing a course of criminal conduct. In all the circumstances, shall be detained in custody pending these reports.
Well, I don't think my legal argument was hopeless at all. I think there was a lot of merit in it. I'm not necessarily suggesting that I thought I would win on it. In a situation like that, I've just got to try. I mean, otherwise, you just tender pleas of guilty all the time. That's the trial. You didn't do very well, did you? No, it's fun. No, we tried as we could. I don't think the sheriff's right.
What's community service report?
Well, as an alternative to prison, they can put you on community service work.
£2.
Well, I know, but they can make wee jobs for you, and if you would prefer that to going to jail, you should indicate that you're willing to do it. I don't suppose, to be honest, it'll affect Sharon a great deal. In the end of the day, it looks like she's going to be in custody for a little while, a few months, and then she'll get out. And who knows what will happen then? Might be more business for us. From a business point of view, she makes a lot of money for us because she's a regular customer and we get paid for doing the job.
That payment comes from taxpayers in the form of legal aid at between £40 and £50 an hour. Sharon's case alone will be worth £500 to Moore & Co.
Last year, in gross fees and outlays, we were paid about £1.5 million by the Legal Aid Board. Well, I think I'm wealthy. I mean, I have a house in the Highlands of Scotland and I own this office. I have a part ownership of an office in Kirkcaldy and in Dunfermline, and we have other properties in Edinburgh, my wife and I.
Hello?
Barbara, would you come up and collect your mail, etc.? Thank you.
And it is George's wife, Barbara, who runs the business.
Are you going to sue Fairbairn, by the way, about these?
Yes, about Reed's case.
Now see this is something that they've written to us, and he's passed the buck. Now, would you see if you can deal with that, but let it come back to me, don't sit on it. No doubt there'll be another letter, so if you can't find anything, tell me, and if you can find something, tell me. And you'll get that certificate for the Law Society. Barbara, don't sit on it either, because I need it done before the end of the month.
Moore & Co are a firm whose clients don't plead guilty to anything unless the evidence is so overwhelming that there is no chance of acquittal. In that category is Christopher Lang, who was caught red-handed by the police fighting in a pub. If convicted on all charges, he will go to jail. So George has struck a deal. or plea bargain. Lang will plead guilty to assault, breach of the peace and criminal damage, and in return the prosecution will drop the most serious charge, assaulting the police.
Today is really a case of trying to play it down, not trying to assert that you had any right to do what you did, saying that you're sorry. Now, has it worried you genuinely, this? You seemed worried when I phoned you.
Oh, unbelievable. I've actually been to the doctors twice because I've got nervous psoriasis because of it.
Well, you must tell me that, because that's important. Nervous... How do you spell psoriasis? Is it P-S... I'll have a stab at it.
In the Sheriff and Jury Court, Murdo is starting a 2-day trial in which he is defending a 20-year-old carpenter, Thomas Glencross.
He faces 4 charges altogether. The first charge is by far and away the most serious. It's causing death by dangerous driving. You can get 5 years of imprisonment for it.
Any sentence will be up to Sheriff Thompson, but first the jury of 15 men and women must decide whether or not Thomas Glencross is guilty.
The thing that really is troublesome is that he drives along the wrong carriageway and collides into this woman.
Are you the sister of the now deceased Sheena Elizabeth Rattray?
Yes, I am.
Of the same address?
Yes.
Thank you. And did you last see her at about 9 a.m. on Monday, the 17th of August last year?
Yes, I did.
And I think in the early afternoon that day, a police officer came to your house and told you that she'd been involved in a serious accident.
That's correct.
And that she had been taken to the Western General Hospital.
That's correct.
And where you advised on the 22nd of August that she had in fact died.
Yes.
And the following day, the 23rd, did you in fact go to the city mortuary? And did you identify the body of your sister?
Yes, I did.
Meanwhile, Christopher Lang's hopes of receiving a fine, not a jail sentence, depend on George's plea in mitigation.
My client frankly admits that he behaved very badly. So much so, my lord, that he's been worried about this in a real way, that he had to consult his doctor about 2 months ago because of a rash which had occurred, and he was diagnosed as having nervous psoriasis. He's one of those people who has got himself into a jam and now realises that he's behaved badly, but is full of contrition and knows that he's got to pay the penalty today. So I would ask my lord to bring this matter to a conclusion today and to dispose of this case by way of financial penalty.
Well, I'll stand up, Christopher Lang. This is completely disgraceful behaviour, drunk or not. You seem to have caused a lot of damage and disruption. Had it been possible to itemise and evaluate the damage to the equipment, then you certainly would have paid for that. As it is, it doesn't seem practicable to do so. I think an overall fine of £500 will meet the situation. I warn you, there better not be any further trouble of this kind, otherwise the court will take a more serious view of your position.
Christopher Lane, you've been fined £500. It's payable at £10 per week, and your first payment due 1 week from today. That's all, thank you.
In the Glencross trial, the prosecution have called a series of eyewitnesses to the fatal crash.
An old-style has got pulled out from the northbound traffic into the fast lane on the southbound traffic and hit the metro head-on.
Have you any idea at all, even approximately, how many yards it was out on the fast lane of the southbound carriageway?
The escort?
Yes.
It was centred between the 2 white lines.
One obstacle which really renders it very likely that he'll be convicted is that he is seen minutes before darting from lane to lane on his own carriageway, but he's obviously a man in a hurry, and then all of a sudden he's seen in the wrong carriageway. So it looks as if he's tried an overtaking move.
Well, it was going in and out all the way up the road.
Did you form any opinion from seeing him going in and out to the inside and outside lanes?
Well, considering the conditions, I would have said he was an idiot.
What happened there?
We were just coming round the corner and seen the car, well, not specifically his car, but seen the car in a distance, and all of a sudden it just shot across the other lane.
This is therefore onto the lane, the wrong side of the road?
That's correct,
And how long did it stay there?
Stay there, you're talking about seconds before it collided with the other car. the two of them just went up, straight up in the air.
Are you able to estimate the speed of that car?
Anyway, 60, something like that.
What speed were you doing?
Either just at 40 or just over 40.
And when you witnessed this accident taking place, how far were you in your van from the accident? Approximately. How many yards?
Maybe about 60, 70, something, maybe something like that.
I have to put it to you, that's quite remarkable, because you've described how this dark car overtook you at some speed, and then you say that it must have driven on for about 1.5 miles at least, and then, miraculously, you're only about 60 yards away from it when you see it crashing. How do you explain that?
No, by the time I come round the corner and where he, as I say, I wasn't too sure. I'm just surmising it's 60.
You're surmising. Well, I have to suggest to you, Mr. Conington, that either you were a lot further away or you were in fact doing approximately the same speed as this vehicle.
Definitely not.
What sort of vehicle did you think it was?
It was a darkish coloured car. I'm sure it was a Ford.
It couldn't have been a light blue Ford Escort?
No, well, not really.
Conington says that he saw a dark coloured car weaving in and out of traffic. In fact, Glenn Cross was driving a light coloured car.
Can I suggest to you then that this may have happened, that you saw a car driving, as you say, in and out for about 1.5 miles beforehand. Then eventually when you come round this corner before the Cramond Inn, you see a vehicle, as you've described, going onto the wrong side of the road and smashing. Might it not have been a different vehicle?
No.
What I have to try and do is convince the jury that it wasn't dangerous driving, that it was perhaps careless driving, because only someone with some sort of death wish would deliberately drive along the wrong side of the carriageway. And it may well be that he fell asleep or something like that.
When my friend asked you to form an opinion as to what you thought, you said it was idiotic that it went into the wrong carriageway. Can I go further and suggest to you it would be positively suicidal for someone to do that in the face of an oncoming vehicle?
Well,
Yes, correct.
yes.
And unless you really wanted to kill yourself, you wouldn't really do that, would you?
Well, to be honest, I don't know why I went across it in the first
No.
place.
You can't offer any explanation at all?
Well, as I say, I can only go by what I seen beforehand, and that it looked as though he was trying to overtake.
But you can't say, well, you've agreed with me that it would be virtually suicidal to do that.
For someone to go across to that other side.
Yes, on the face of oncoming traffic.
That's correct,
Thank you.
Today, Murdo will continue trying to keep Thomas Glencross out of jail, while George has a more mundane problem on his hands.
I'm just going to pump it. No, you're not going away. You're staying here, and we'll do our best. I can run it.
His client, Robert Allen, thinks that he will be found guilty of breach of the peace and resisting arrest. Rather than risk jail, he wants simply to run away before the trial begins.
But you've got to just trust me to fight it, isn't it? If you run away from the court and go away, you'll be arrested, you'll be locked up without doubt. If you then plead guilty, you'll get the exact same as if you've been found guilty today. So you may as well take your chance today. Morning.
If he can stop his client absconding, George will have to take on police witnesses who will say Robert violently resisted arrest when they try to question him about an unpaid taxi fare. Robert denies this, but can't remember what he said in his original statement.
You said you heard a knock at the door. I went to the door and opened it, and I saw the police officer standing there. Now, do you remember that or not?
Aye.
As soon as I opened the door, they tried to walk in, and I tried to stop them. Do you remember that? Aye. Is that right? I asked him if they had a search warrant, and he said no. I then said, take your feet out the door till I shut the door.
Aye.
Is that right? They kept trying to push in, and I kept trying to push them out. right? They said that I'd been arrested for, and these were your words, cheek and insolence. Criminals tend not to think of the consequences of their own actions. And it doesn't matter how many times they've been caught, how many times they've been jailed, they still commit the same sort of offences. I can't understand it myself because I'm not that sort of person, but that's the only way I can describe it. Somebody with a time horizon of about 3 minutes who never thinks ahead. This is about the worst case in the world today. It's Robert Allen fighting with the police, but the trouble with him is he gave me quite a detailed statement in July last year, and he can hardly remember anything now, and he doesn't want to give evidence. So what chance have you got against two policemen saying he was shouting ball? There's a slight legal argument, that's the only hint of a chance in it, that they tried to push their way into a house, and he was just shoving the door closed on them, which he's entitled to do.
Thomas Glencross suffered a total memory loss as a result of his injuries and so can tell the jury nothing about the crash. Nevertheless, Murdo has decided that he should give evidence.
Visibly, he doesn't look to be that badly hurt, although he was very badly hurt. But to a degree, the jury will want to see that he has received some sort of punishment, or they will do that today. And if he had been badly injured, maybe facially, perversely, it would have been better for him in the long run, I think.
Take the oath, please. I swear by Almighty God.
You know, if he'd come in a wheelchair, put it that way, I think you'd have got the jury's sympathy.
Go.
Obliged. Can you tell us, please, what happened to you? What injuries you sustained?
Well, I had badly bruised legs, I had cracked ribs and badly bruised ribs, and I smashed all my face in, split my head right down there.
Right.
And I smashed all my cheekbones and smashed all my face into bits.
And what about your jaw?
Well, that was all snapped and I had to get it all rewired and all my jaws and everything.
Right, so you had broken cheekbones and jaw?
Aye, and I pushed my eyes and my nose into my head.
Right, and I think you've had quite a few operations since then, is that correct? And in fact, am I right in thinking that there's now plastic inside your cheekbones?
Well, I've got wires and I've got three metal plates along there.
Right, right. So there was quite a lot of damage done then. And tell me, were you told about the driver of the other car? And how did you react when you found out that she had died?
Just baggy, cracked up.
So did you say you're cracked up?
Just...
Is it? Yes.
What do you mean by that? Do you feel quite bad about it?
I feel bad, like.
I just say this to you, I know you're a very rigid sort of individual. You wouldn't fancy a breach of the peace involving struggling.
George, meanwhile, is trying to plea bargain with the prosecution.
It's a very minor incident of its sort. I mean, you should never have got to. He won't accept the plea, so we'll have a trial, right? All right. You have to stay here, right?
No, see, the police don't like me, Calder.
I know, but they also might not like getting taken on in court. So.
Oh, but they want to stitch me up.
All right, it's all right, Robert. You've got to have a wee bit of courage sometimes, okay? Don't call me George, please, in the court. Mr. Moore's my name, okay? And be polite to the fiscal. Just call him sir, or the sheriff, sir. Just be polite. It's very much a game. You've got to play by the rules.
When you're ready to start, Mr. Fiscal.
First witness, Lord, is Constable Alexander Chalmers, please.
So you'll take the oath, hold up your hand and repeat these words. I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
Constable Chalmers tells the court that he tried to enter a crowded flat to investigate an unpaid taxi fare, but was confronted with abuse and threats from Robert Allen. When he tried to arrest him for breach of the peace, he was only able to do so with the help of two other officers.
What did you write down about the incident which gave rise to my client's arrest? Breach of the peace and resisting arrest.
Yeah.
What have you written down about that?
Right. 6 or so other youths involved, but mainly Alan, causing the disturbance, which looked like escalating due to his loud abuse. He was warned, refused to resist, and told he was under arrest for breach of the peace. Began flailing his arms around, continued to shout and swear, and required to be handcuffed.
You see, when you gave evidence, when the Procurator Fiscal asked you questions, when you first entered this house, you said that my client said, "Who let that black bastard in? Get that cunt out of here."
Yeah.
Where does this come from?
That was one of the things he said just at the beginning of it.
It's not in your notebook.
No, it's right, sir.
So where does it come from?
From a memory of the,
I see.
event, from having been asked those questions.
So what you're saying is that about a year after the event, you have remembered these exact words as said by my client.
These were certainly the gist of it.
What you wrote in your notebook was, if you come in any further, I'm going to flatten both of you.
Yeah.
That's different.
That was part of it, yes.
Mm-hmm. You see, the truth of the matter is, Constable, that when you came to the door and knocked on the door or rang the bell, this young man came to the door and told you you couldn't get in. And that made you very angry. Is that not what happened?
No, sir.
And he asked if you had a warrant to come in. And you said no. He said, "You can't come in." And in actual fact, he said words like, "Take your feet out of the door till I shut the door."
Mr. Allen started shouting and swearing with his arms flailing and sort of pushing towards us.
So that's just made up, Constable, isn't it?
No, not at all.
Shouting and swearing, flailing his arms, lunging at you. Is that in your notes that you made at the time?
No, sir, not at
No.
all.
But it's something you now remember.
Yes?
It's just added in to make it more difficult for this young man.
No, not at all, sir.
Shouting, swearing, flailing, lunging. All of these things you say happened.
Yes, all these things happen, sir.
I see. You don't very often win a criminal trial by your client going into witness box and creating reasonable doubt in the sheriff's mind. You're more likely to win it in the Crown case by challenging the Crown witnesses effectively to show them not to be credible and reliable. I put it to you, Constable, that my client did not struggle with you at any time and certainly did not struggle violently with you.
No, he was very violent, sir.
That's the first time you've mentioned these words, very violent. Let me put it to you that this is what happened. That my client annoyed you because he wouldn't let you into the house. That you pushed your way in and decided that he should be arrested because he refused to let you into the house. There was no other reason for it.
No, you can suggest what you want, Mr. Moore.
Well, I'm suggesting that you told him later, when he asked you why he had been arrested, you said, "For cheek and insolence."
No, so these words have come from yourself or your client. I don't use the words cheek and insolence at all.
2 more police witnesses give similar evidence about Robert Allen's behaviour, but contradictions begin to emerge. The second officer says he was arrested in the living room, not the hall, and the third gives a different explanation of why they decided to arrest him in the first place.
When you came into the house, this man, the accused, came into the hallway of the house.
Yes.
And I think you said it was your intention to detain him.
That was my intention when I left the street, yes.
And this was in connection with the taxi fraud.
Yes.
And you attempted to detain him.
Yes.
And it was in the attempt to detain him that you say that he struggled. So you had to arrest him.
As I also said, sir, yes, there was a lot of shouting and swearing being made by your client as well.
He was having none of it, is that right?
He was having none of anything, sir.
Right. He was having none of this allegation in any event.
Well, it was impossible to find out whether he was having any of the allegations, sir, because he wouldn't speak to us.
Wouldn't speak
All he
to
would
you.
do was shout and swear at us.
All right. But what you did was you attempted to detain him.
Yes.
In relation to the taxi fraud.
Yes.
And then he struggled.
He began to struggle, yes.
And then you decided then to arrest him.
Yes.
And then you told him that he was arrested for a breach of the peace and for resisting arrest.
Yes.
Right. Thank you.
We have 2 charges.
In the Sheriff and Jury Court, the Fiscal is summing up the case against Thomas Glenncross.
Now, ladies and gentlemen, what do you think? 70 yards on a dual carriageway on a road like that, to sit in the wrong lane, is that or is that not dangerous driving? And perhaps you would look at what the definition of dangerous driving is. The way he drives falls far below what would be expected of a competent and careful driver.
Effectively, the jury have to sit on the touchline and have to assess objectively, is his driving dangerous?
And apart from that, I have nothing else to say, ladies and gentlemen of the jury, other than to thank you for the courtesy of your attention. Thank you.
It is a sliding scale, and somewhere at the top there is desperately dangerous driving, very dangerous, then there's careless driving, and then there's normal driving. What I have to try and do is bring them down towards the level of careless driving.
I'm obliged, my lord. Now, ladies and gentlemen, my friend has gone on at length about the evidence which she is trying to turn your attention to. The burden of proof is entirely on my friend's shoulders, and she has to satisfy you beyond any reasonable doubt that all the charges which are left should lead to convictions of the accused. Now, Mr. Glencross was just an ordinary driver like you, ladies and gentlemen, or like anyone else would be. So if you were to convict him here, you would have to be satisfied that this driver, quite ordinarily a careful driver, has gone into the fast lane of an oncoming carriageway with cars coming towards him. I must put it to you, ladies and gentlemen, that that is almost such an unreal situation that it couldn't have been carried out by, in effect, a deliberate bad piece of driving. But something must have happened. He may have been tired, and that may have resulted in him veering off course. It may have been that Mr. Glencross was trying to turn right. Now, do you consider that if he was trying to turn right, then that amounted to dangerous driving? Or do you think that it was perhaps an error of judgment? The act of bad driving can sometimes be very, very small in comparison to the tragic consequences which follow. Although he did veer, for whatever reason, into the wrong carriageway, there may well have been nothing there, and he may well have gone back into his own carriageway, and nothing would have happened, and we wouldn't have been here today. Unfortunately, this tragic accident did happen. And I would urge you to think, perhaps, that it's a case of there, but for the grace of God go I. If you feel that the evidence merits him being convicted of causing her death by dangerous driving, then of course you must return that verdict. But at the end of the day, ladies and gentlemen, is it not in fact the case that he was perhaps driving without due care and attention? We don't know. We can only make certain assumptions, and I would urge you to give him the benefit of the doubt.
In his summing up, George argues that Robert Allen's behaviour was reasonable because his arrest was technically illegal. He then moves on to the contradictions in the police evidence.
Now, it seems to me, my lord, that it's difficult for you, as I think you've expressed the view, that to see how these three accounts of events hang together. And it would be difficult to make findings, in fact, as to actually what happened prior to the moment that hands were laid on my client. And so I submit, my lord, that the Crown should fail in this prosecution, and you should return a verdict of either not guilty or not proven.
What is clear to me is that I have three different versions from the three police witnesses, and these are versions which are different in quite important respects. I'm quite at a loss to see which version I am to prefer, but as I'm not able to come to a view as to the important surrounding circumstances due to very material discrepancies among all three police witnesses, I am therefore not in a position to consider what the circumstances were and to come to a view as to whether on any particular facts he is guilty or not. I therefore find him not guilty on both charges.
You found not guilty in respect of both charges, that's all.
Excellent.
Never seen better. Where could you get better than that? Yeah, you ripped him apart in there.
For Thomas Glencross, the jury return after considering their verdict for half an hour. The question is, will they find him guilty of causing death by dangerous driving, or has Murdo persuaded them that his driving was merely careless?
The jury don't know what the sentences are. They don't know that he can get 5 years for death by dangerous driving, yet he can't get anything jail-wise for a careless driving.
Have the jury reached a verdict?
No.
Have the jury agreed upon their verdict? No. And what is your verdict, please, in respect of charge 1?
Guilty by careless driving.
Is that unanimous or by majority?
Unanimous.
Your verdict in respect of charge 2?
Not guilty.
Unanimous or by majority?
Unanimous.
Thank you. That's all just now, thank you. You're free to leave.
Court, please rise. I just can't believe the verdict. They've found him guilty of a charge of careless driving. There's no way you can go to prison for it. Right, Thomas. You're a very lucky man, Thomas. Okay, how do you feel? Well, you'll get a few penalty points and a wee fine. Give us a phone, Thomas. Okay then. Cheers just now.
A conviction for careless driving means that, legally speaking, Thomas Glencross has not caused a death. He was fined £250 and lost his licence for 18 months.
We'll go back in and just have a quick one with this one.
Oh, I'm going to head in.
Okay, don't do anything stupid and get drunk and make a fool of yourself. Cheerio. Right. He will take drink again, and he will do something stupid, and he's an easy target for the police because he'll draw attention to himself by doing something silly. He's not a bad criminal. I've been doing this job for 27 years. I don't think badness and goodness comes into it. There are very few people that I would be worried about who commit crimes, and the vast majority are just feckless, inadequate people.
Sharon Graham was jailed for 4 months. Since her release, she's been charged with other shoplifting offences. Shortly after his acquittal, Robert Allen was again arrested and charged with breach of the peace and theft. Thomas Glencross will have his licence returned to him early next year. Murdo MacLeod has left Moore & Co. and is now an advocate in the High Court. In the last year, every qualified solicitor in George's Edinburgh office has resigned or been sacked. George has recruited new staff and is as busy as ever.